Probated or not probated investments. When an individual dies owning financial investments, be it stocks, bonds, mutual funds, brokerage accounts, bank accounts, RRSPs, RRFs, or life insurance proceeds, the executor of the deceased person's estate will need to effect the transfer of those investments with the financial institution that has legal purview over that particular investment. And to effect that investment transfer, the executor of the deceased person's estate will need to consider whether or not the financial institution will require the estate to be probated or not, such that the appropriate procedure is undertaken to settle the deceased person's estate. In Alberta, an estate is probated with a valid will. However, where there is no will or the will is inadequate, the process is administration and gaining a grant of administration. To understand whether an investment requires probating the estate or not, the decision rests with a specific financial institution and their internal policies. Although there are certain indices that would be indicative of transfer being undertaken with or without probate. The two primary methods by which investments circumvent the need for probate are 1. Naming a beneficiary with the financial institution, and 2. Owning the investment jointly with the right of survivorship. Naming a beneficiary with the financial institution. When the investment owner plans a future transfer with the financial institution in accordance with their stated procedures, those transferences are intended to satisfy the financial institution's own policies for effecting a transfer on death to the named beneficiaries. This enables the financial institution to be assured that the arrangement that has been implemented in accordance with its own policy satisfies their requirements, legal and otherwise, for transference. And provided the specified transference proceeds as set on the financial institution's own paperwork, it may proceed without the need to be probated, if that was the intended structure and this remains the financial institution's position. However, should there be issues associated with the transfer to the named beneficiaries, such as their own death, there be legal issues with the intended distribution, such as the attempted circumvention of statute-protected beneficiaries, technicalities in the financial institution's paperwork, etc., attaining a grant of probate or grant of administration may well be necessitated to settle the deceased person's estate. Joint ownership of investments. Joint ownership of investments with a right of survivorship is also capable of circumventing the need for a grant of probate, where the surviving joint owner is capable of continuing as the owner of the investment and the financial institution's position is not to require a grant of probate. Nevertheless, if there is no surviving joint owner, or the fine print in the financial institution's paperwork states otherwise, the investment assets would be subject to be probated, and the executor could well be necessitated to attain a court-issued grant of probate. The fact that investments need to be probated is not as deleterious as certain commentators have made it out to be, especially in a province such as Alberta, where court probate fees are some of the lowest in the country, and lawyer fees for non-contentious, straightforward estates tend to be quite reasonable, especially when one considers how much more tends to be spent with probate avoidance strategies, which need to be created, maintained, and implemented on death, all with considerable costs and other possibly adverse results, such as one's loss of control, such that probate can be timely, cost-efficient, and provide appropriate legal protections and security in the legitimate distribution of the deceased person's estate, both their investments and other assets. For wills, estate planning, and probate matters in Alberta, contact our law firm to learn how we can be of assistance and schedule an initial confidential consultation. Thank you.